All right. So you guys want to continuance, kind of tell me what's going on.
Yeah, so I think we're kind of on the same page. We're just looking for a little guidance from the court on what to expect. You know, I think it's unlikely that will be reached on our current trial setting, which is pretty soon, since it's not a terribly old case. So we're currently set for July the 6th. So the defendants have requested a continuance. We are not necessarily opposed. We were just hoping to have a little guidance from the court, and then hopefully we can find a new date that works for everyone.
All right, let me just look at this real quick. Okay, so yeah, you're set on as a non-jury case on July 6th. Is it going to maintain? Is this the one that's has a jury waiver on it?
We have a separate hearing set, Your Honor, on that issue. I think that's probably up for dispute, but that's set for a different hearing on a different day.
Oh, the reason I'm asking is just if it's going to stay as a non-jury case, I'd like to get it tried sooner because I'm trying to get as many of those done before we kind of start. We're I don't know if Ms. McIntyre is aware of this, but in Dallas County, we're on a rotation where the judges get basically 1 week out of the month or 1 day out of the month to be able to pick juries. So we're mostly doing just non-jury cases, but we're doing a few jury cases. And then once that's over, I anticipate and hope that we'll be going back to some semblance of normal. And so if you want to stay as a non-jury, I'd like to get it tried before we're done with this rotation, which is the beginning of August. If you're going to go to jury, then it really doesn't matter because then we're going to be, I mean, you're right, Ms. Greason, that it's probably going to be months and months, if not years and years before we actually get to trial if it's a jury case. So I guess that's part of my thought process is, so there's a non-jury waiver, but it's, there's a question about whether it's enforceable. Is that the issue?
That is actually in a different case. So that's in the FSG case right now before the court. This unopposed motion for continuance is the Delgado case. So they're two separate cases.
So does this one have a non-jury waiver as well?
This one is on the non-jury docket, and plaintiffs are not requesting a jury trial. We believe there should not be a jury trial in this case.
But is there a jury? Is there a chance this could become a jury case? I guess is what I'm trying to get at.
I believe the defendants would say yes. The plaintiffs would say no.
Is there and there's not a jury waiver on this case?
I think plaintiffs will say there is a jury waiver.
Okay.
I think defendants will dispute the scope of it.
Okay, that's what I'm trying to get. So there is a jury waiver. It just there's a question about the scope of it. In this case, because she says it's in the TSG case, there's a jury waiver.
It's in both. I mean, maybe they're not disputing the jury waiver here. I guess I will defer to them on that issue.
Mr.
Rowe. Go ahead.
I apologize, Your Honor. I thought you were talking about the actual motion that we filed to strike the jury waiver and all that argument that we heard earlier. That is for a different case. So that's what I was commenting on.
Are you guys going to be requesting a jury or trying to request a jury trial case in this or not? Or what is our?
Yes, Your Honor, that we will be, and we don't believe there's a jury trial waiver at issue in this case. It will be litigated in the 5-star global case, but we believe that this will be a jury case in the Delgado matter.
Even though there's a jury waiver, but you think it's not enforceable or beyond the scope, is that?
Your Honor, we don't believe a jury waiver applies to the claims at issue in the Delgado case. There's not a breach of the agreement that had the jury waiver that as in the other case where it's being litigated, and there's been no motion to strike a jury waiver filed by plaintiffs in our case at all. So we don't think we think this will be a jury trial.
It's correct. Okay. So if we continue this, then we may have to fight out this whole issue involving the jury waiver, I guess. Is that right?
I believe so, Your Honor.
Okay. Well, maybe we shouldn't maybe we shouldn't continue as to just get this case over with. I have a million cases at this point, and so those that I can get rid of more easily, maybe we just do this one now then. Is there a reason we can't try it now?
I think that my clients would be happy to try it now.
Yes, Your Honor. So let me back up a little bit. The reason that we filed this motion for continuance or the unopposed motion is because, I guess, taking us back to kind of discovery in this case, we tried to get through as much as possible. Opposing counsel delayed over, I want to say it's like 6 months to get us our production. And when they finally got us the production, it was roughly 80,000 pages, which we mentioned in our motion. We spent a significant amount of time going through this production, and we just finally started to get depositions on the calendar at the end of April, but we still have a significant amount of depositions that need to be taken and further steps that we need to take in discovery, which is why we are requesting this continuance.
There's quite a few different cases. So what is this case about, the Delgado versus Hume case? I know they're all kind of interrelated.
Mr. Delgado was the former CEO of the 5-Star. So we filed a separate case against him. The other side, the defendants in this case, and I believe the defendants in the global case, which are now the same counsel, not previously though, requested that these cases not be consolidated. We didn't care all that much, frankly, on whether or not they were consolidated or not. They have contended over and over that these are not related. So for that reason, they're not combined, which we're fine with. This case is pretty narrow. I know Mr. Silvas isn't on this hearing, but on a call, I guess it was last week with Mr. Silvas, I mean, he acknowledges this case is pretty narrow. So
what is it about exactly? What do you mean?
It is about we allege that Mr. Delgado, as CEO, essentially contemplated and was part of the demise of my clients. My client was was the founder of the company, and so we allege that he was kind of the one that crafted this whole way to get my client thrown out of the company. So we've claimed breach of fiduciary duty and fraud in the inducement. And then I believe we also have a negligent misrepresentation and fraud by non-disclosure. But they're pretty narrow issues. My client had made a couple of payments to Mr. Delgado as part of this other agreement. And then our position that while our client was paying these substantial funds to Mr. Delgado was finding a way to get my client ousted from his own company.
So what discovery, Ms. Greason, do you need in this case to get ready for trial?
I don't think we need anything other than what we got. We obviously had objected to the scope of the defendant's request, but the ugly reality was when you ask for the moon, you get the moon, and so it certainly was a huge amount of discovery that we've given to them. But I don't think there's anything significant that we need. The issues, as I said, are pretty narrow.
Have you already taken Mr. Delgado's deposition?
We have, Your Honor.
And have they taken your client's deposition?
They started it, and then they did not finish it because they wanted to see if they could get some settlement authority, which didn't come through. And so they need to finish my client's deposition.
Okay.
But I think quite a few hours were already used. I don't know how much is left, but it shouldn't be that much. And we can do that quickly.
Your Honor, that's correct. We still have discovery to do. Plaintiffs sent out requests not too long ago that we still have to respond to. And we have other depositions that we need to take in this case.
What other depositions?
We still need to finish up the deposition of Mark Hume, and then we also need to take the deposition of John Harrison and a couple other individuals.
Who are the other individuals? Mr. Harrison, who is that?
Mr. Harrison was the former CFO, and he had a lot of sway with a lot of the financial matters and things that happened with the company. So we need to take his deposition moving forward, and we need to finish up Mark's. And right now, I think that's it, although I know we've talked about possibly taking some other depositions.
Yeah, and Your Honor, I'll just add that we, in a recently, a response to a request for disclosure, there are some new fact witnesses that were identified by plaintiffs. So those would be, at least a couple of them will be deposed probably, but more importantly, Your Honor, we've got expert discovery, and that's ongoing. A lot of that was we needed our discovery to get our experts going, and that's probably going to be one of the most burdensome aspects. One of the most reasons necessary for having this continuous granted, and we thought we were on the same page with opposing counsel that some continues to be warranted. I think maybe we do have to find out what the appropriate amount would be, but probably for the key depositions and experts, why we need more time, Your Honor.
The only thing I'll add, Your Honor, if I may, on the experts is we didn't, I will double check, but we didn't disclose any experts other than the two that they've deposed, which are, they're going to depose, which is Mr. Hall and Mr. Harrison. I don't believe we even retained any other experts other than those two. So it's pretty narrow still.
So I guess my concern, and this is really just COVID related, is that we have been 1 year and 3 months without trying jury trials. And so our backlog is massive. And this is a case I could resolve before we begin that process. And now you're also wanting to put this on the jury trial docket and not consolidate it with these other what seem to be related cases, but I guess I don't know all the facts of them. And so I guess that's my concern is if we can get this case resolved, let's get this case resolved. I don't mind moving it maybe a week. I mean, would that help? Would that allow you to take Mr. Harrison and Mr. Hume's deposition?
Your Honor, I think a week would be too short of an amount of time because we still have to go through a lot of the expert stuff on our side. We did designate 2 separate experts and still have to work with them make sure that their reports and everything else gets sent out. And a lot of that hinged on plaintiff's production and the production of a lot of those financial documents and getting those over to the experts. So there was a significant delay that we faced, and that's why we need a little bit more time.
How do you address my concern then?
Your concern regarding the jury trial?
Yeah, I mean, yeah, we have massive number of cases. This is a case I can resolve now. Why not just do it now? I mean, and you're not agreeing to consolidate this with another case that would help. I mean, you're proposing using a lot more court resources at a time when it's going to be very hard for me to be able to devote court resources by having 2 separate jury trials. What could be 2 bench trials that would be fairly quick to resolve. You're proposing 2 separate jury trials. And it's a time when it's going to be really hard to get you dates. Every week we have 15, 20 jury trials set. Why not get this done now before we start all of that? I mean, I understand it, but Ms. Greason seems to think that she doesn't need any additional discovery.
Your Honor, I would say that, we could talk to Ms. Greason about consolidation, actually, if that would be helpful to the court's administrative challenges, then we could talk to him about that, because we definitely feel in the Delgado case, we absolutely, our clients need more time to develop their case. And so if the way we can balance this is consolidation, we can talk to Ms. Greason about it.
And in the other case that is a TSG case, I guess there's 2 issues. One is 2 jury trials. Right now they're both bench trials, and you guys are wanting a jury. She's not wanting a jury. And then the other issue is then the consolidation. What is your view on keeping these just as a non-jury case?
I could be wrong, and Ms. McIntyre, she's really good with the facts and the history, so she can correct me. But the 5-Star Global case, I think we're actually set for jury trial, and the argument is to try to transition it to a non-jury. So right now that is jury, and we're going to demand a jury for this one. So we think we actually, if consolidation were to occur, just be 1 jury trial.
That's correct, Your Honor.
Ms. Greason, what are your thoughts on that?
They are the ones that have requested adamantly that these cases not be consolidated. I haven't addressed that issue with my client in quite some time because the court, unfortunately for me, sided with them on that issue way back when, or you at least said that you were going to wait rather than consolidating them at the time. So I haven't discussed that issue with my client recently. I know my clients do want this case tried and as quickly as possible because it's narrow.
Because once it gets into the jury trial pipeline, just Ms. Greason, my guess is it's going to be another 1 to 2 years before we get to trial at best. I mean, this is a 2020 case, And I have 2017, 2018 cases I'm trying now. And so if it's a non-jury and you can keep it a non-jury and you can do it now, I can do it within, I don't have to do it on the 6th. I can do it anytime in July. We could do it even the last week of July. But once you put it into the jury trial pipeline, I can't make any guarantees I'm going to get to this. Not that I don't want to get to it. I think it's an interesting case with good lawyers on both sides, but it's just going to be a long, long time before we get to it. So
we would love to try this case to the bench the last week in July, and I think that would give the defendants more time, and we can make whatever witnesses available that they need available. We don't, I mean, my client is only Mr. Harrison and Mr. Holmes. So if they want to take third-party depots, I'm certainly not going to stand in the way of that. We can get those done. But there are no other, the company is so small and the issue is so narrow that I think that would give them sufficient time. I haven't requested a depot of their expert. I don't intend to. We're ready.
Your Honor, maybe the way then, because we're going to demand a jury trial. It sounds like we haven't litigated the jury waiver issue in this case. I know it is confusing because of the 5-Star Global case where it has actually been briefed, but it looks like if this is going to be the determination, we may just have to brief it because we're going to demand a jury. And if
has there been a jury trial requested in this case?
So there has, I don't know if the defendants have. The plaintiffs, we certainly did at one point in time. I know. I'll double check right now to see if the defendants did and their answer. I don't recall offhand, but it's been set on the non-jury docket from the beginning. And I know certainly no jury fee has been paid, and at this point we are within 30 days of the trial. We certainly haven't paid one. I don't believe the defendants have.
Wait, so a jury trial has, or a jury fee has or has not been paid in this case?
No, Your Honor, has not been paid.
It's not been paid, okay. So if we try this within the next 30 days, there's no way to request a jury.
That's correct, Your Honor. It looks like the defendants did list a jury demand in their pleading, but like I said, we're within 30 days and no fee has been paid.
And when did they demand a jury?
It looks like they did back in 2020 when they filed. Only thing I'm seeing is they filed an original answer. I don't see any amended answer from them.
Let's see.
So it looks like it was filed on 7/13 of 2020.
That's correct, Your Honor. We demanded a jury along with our answer, and then plaintiffs in their original petition demanded a jury as well.
But they never pay. So this gets we've been dealing with this issue a lot lately. So the issue is they demanded a jury, but they never paid the fee.
Correct.
Okay, so yeah, that's come up in other cases. That's interesting. I think probably the best thing to do is for you guys to just talk about it. If you want to, I'm not opposed if you want to consolidate it and have it all as either a jury or non-jury case in the other case, whatever the determination is going to be. If you're going to insist on 2 different jury trials, then I'm inclined just to keep it where it is on July 6th and just try it then. And then you guys can brief whether or not you can try to brief whether or not the jury demand without paying the jury fee in this case would be sufficient to invoke the jury trial, and then the jury trial waiver if there's one in this case. But what I would suggest we do is maybe you guys, it sounds like you both need to talk to your clients about the consolidation. Is that right?
Yes, Your Honor.
I think so.
Yes, Your Honor.
Okay. So just to make it clear, so if I mean, I'd prefer to just try it and get it done. But if it's going to be a huge issue, then I'm willing to allow this to be consolidated and then just try it as one case and then either as jury or non-jury, depending on what that case does. And if you can't agree to the consolidation, then I'm inclined to just try it sometime in July, and you guys can brief the issue of whether or not you can demand a jury at this late date. So,
I will say, just so I'm being transparent on this issue, my guess is if this is combined with the other case and you're saying that might take a year or 2 years, I can go ahead and have a strong prediction that my client will say absolutely no consolidation. We want to resolve this one as quickly as we can. I don't think it's a long case. I think it's really, really short. So I don't want there to be any surprise that I'm you know, thinking that a
Well, if
consolidation will
that's
take-
okay, if that's the case, then I think we probably, trying to think how to do this.
Your Honor, if we're already set on a non-jury trial right now, we could always just move it a little bit, maybe like a month or two, and that'll give us time to speak with our clients, and then we could reassess. Okay.
The problem with that is that once jury trials start up, I'm going to be in jury trials forever. I mean, I can't tell you what my docket looks like. It's horrible. It's every week I have 15 to 20 jury trials set on cases that have been set 5, 6, 7, 8 times during COVID. These are cases that are not going to settle. I'm one judge. And so I wish that COVID had never happened, but we're in a situation where, and if it's okay with Ms. Greason's client and she's okay with taking the risk that this may take a year or two or more to get to trial, I'm not opposed to it all being a jury case. I don't really care. It's just, we're just so backed up.
Yeah, we
And
will, I
so-
can assure Your Honor that we will be adamantly opposed to this all being a jury trial. I mean, there's jury waivers in this case on purpose, and we're going to consistently take the position that all parties should be held to that.
Yeah, I don't. See, if we move it more than 21 days, and pay a jury fee today, that changes the dynamic
Yeah,
as well.
I mean, under Rule 216, I think that they're now saying this should be removed from the non-jury docket and put on the jury docket. Under 216A, they would have had to have done that 30 days before trial, which has since passed.
Your Honor, I understand the timing issue and the jury fee issue, but you know, the motion before the court is an unopposed motion for continuance. We've been corresponding with plaintiffs for, it may have gone back 2 months, maybe a month and a half again. My fact checker, Ms. McIntyre, can correct me, but the plaintiffs, opposing counsel agreed to a short continuance, and we didn't agree to the timing. So we've been operating under the assumption that a continuance was certainly going to happen. Both sides agreed to it. If that weren't the case, perhaps we would have paid the jury fee if we thought there was a realistic chance we'd go in just a couple of weeks, but we've been operating under the assumption that this is agreed to and not opposed. This is the first time we've heard that it's actually opposed.
Did Ms. Greason, did you represent that I was going to grant the motion?
I have many times had my joint motions denied, so I know better than to predict that Your Honor is going to grant a joint motion.
I mean, I don't think it was her call to do that. I'm really trying to be fair here, and I'm trying to figure out how to do this in a way that's as fair as possible to both sides, but also recognizing that, and you know, we just have very limited resources.
I also was not aware that they were going to demand that this be switched from the non-jury docket to the jury docket, because we've all operated since we received this notice that this is the first I've heard that they were going to be attempting to move it to the jury docket.
Yeah, Your Honor, maybe a solution, although I have talked to my client, is if we can, to fix this for everyone, possibly agree to a bench trial in October when the 5-star global matter is set. We could potentially consolidate both cases and have a bench trial. That would be more amenable. But I say that just brainstorm and try to figure out a solution. I would have to talk to my client.
I'm going to have a problem in October because of all the jury trials. If you guys wanted, this is not an ideal situation. I don't know what y'all's, but once we get past this period right now where we've been, and assuming we start jury trials in August, which I think is going to happen, but again, it may turn out that if we have to keep extending out this rotation system, then I'll have plenty of time to do a bench trial. But once we start jury trials, I anticipate that we're going to be in trial. We don't have any jury trials scheduled or non-jury week scheduled until December 28th. And so I could set you on a non-jury docket on December 28th. That would be my next non-jury docket. So if you wanted to try it on December 28th as a non-jury and you guys can all agree to that, we could try both cases that date. I know that's not ideal. I know people have vacations and stuff like that. It's just, you know, I apologize for COVID-19, but that's what we're looking at. So if you guys wanted to all agree to that and do it as a bench trial on December 19th to December 28th, I would specially set you then, and we could, if you could promise you could do it within 4 days. If not, well, that's one option. I don't know what else. There's other options too. We could keep it in July. We could fight this out. I don't know. I mean, you guys could agree to do a jury trial. There's a variety of things you could do.
Your
I
Honor,
think if the defendants would agree to have both cases set as a special set on December 28th as a bench trial, I can almost say with certainty that my client would agree to that, as long as there's agreement that we're trying everything together in one consolidated bench trial on the 28th of December.
Your Honor, we'll definitely take it to our clients. I don't know what they'll say, but I think that might be the only workable solution. And so if we have to twist our arm, we will, but I'll bring it to them and see if we can do that.
Okay. So why don't we do this? Let's reconvene in a week at 1:30. Does that work next Monday at 1:30?
Give me one moment, Your Honor.
Works for me, Your Honor.
I will be in mediation at that moment, but I can hopefully have someone else cover.
Do you want me to, what time does your mediation start?
Starts at 1.
You want to do it in the morning?
Give me 1 second. It's the 28th.
Your Honor, that morning at 9:15, we actually have a hearing on the motion to strike jury demand and enforce waivers in the FSG case. So
Okay. Well, let's do that at the same time.
Yeah, it might work well.
Perfect.
Sounds good. So that's at 9:15. So we'll reset this motion for continuance then. And also, feel free to brainstorm. I'm not saying that these are the only solutions. I'm just trying to be honest to you about my docket. And so, another option would be if we could agree to a visiting judge, a particular visiting judge. I might try to get a visiting judge if you guys would agree to pay for the court reporter. And we could do that as a jury or non-jury. You'd have a lot more latitude with that. I don't mind taking the visiting judge salary out of my visiting judge budget, but I don't have funds for a court reporter. So you'd have to agree to pay for a court reporter. We could do that either as a jury or non-jury. We could do, I'm sure there's other solutions I can't think of, but those are ideas that I have. And I think we could probably get like Jim Jordan to do that, or maybe Marty Lowy are possibilities for that. Who am I forgetting? Yeah, those are definitely, both of those are possibilities I can try to reach out to. I think Jordan is more likely to do it than Lowy, is my impression, but or if there's somebody you guys could both agree to for a visiting judge, but the person has to qualify to be a visiting judge for me to be able to pay for it. So you can't just choose, your friend Bob, who happens to be an attorney, and has to be somebody who qualifies as a visiting judge. Anyway, anything else, guys?
No, Your
For
Honor.
Your Honor.
Your Honor.
All right, we'll see you next week. Have a great week.
All right. Thank you.
Okay.
Guys.
Thank you.
All right, bye-bye.